Jails, prisons, temporary confinement areas. These are all issues that we're going to address and the liabilities associated with them in this particular dialogue. Now, most law enforcement agencies, they may not have detention centers, or they only have temporary holding cells. But then other law enforcement agencies like the Broward Sheriff's Department runs huge correctional institutions for inmates because we are responsible for housing of all arrestees until their final sentencing by a judge. So other municipal police departments, city departments, they will bring their prisoners to our main jail. We actually have three or four facilities, huge complexes. And that's when they are booked into the jail, and then BSO, the Broward Sheriff's Office, takes custody of them. But to some degree, this particular lecture applies to all law enforcement agencies because the intake of the inmate in the back of the seat and the transportation to a correctional institution or a jail or a holding bay or jail cell, there are legal duties owed. So let's first start with the traditional negligence principles. And as we've talked about before, if any law enforcement agency falls short in their duty of care under a reasonable duty of care standard for custody, transportation, and care of inmates, they can be sued for negligence. That's non-intentional tort of negligence. Legal duties are owed to inmates. They arise from laws, customs, judicial decisions, and various agencies' rules and regulations. So there is a general duty of care. States courts have recognized that law enforcement officials have a general duty of care to persons in their custody to act reasonably. However, under certain special circumstances, a special duty of care, a heightened duty of care can arise because maybe the inmate is disabled or intoxicated to the degree that they have lost their functionality. Maybe they're facing mental challenges or at a disturbed state of mind or diminished ability for self-protection. These are all when special duties, heightened duties of care, apply to law enforcement personnel when handling inmates. Now, as you recall, we had talked about the four elements of a non-intentional tort called negligence. The first element is duty, duty of care. There's a general duty of care that applies here, but then it may be heightened to a special duty, as we just talked about. The next element to prove a negligence case, and remember, the inmate would be the plaintiff in this situation. They would have to prove all these elements by preponderance of the evidence. That's the civil standard. Would be breach of that duty by the correctional institution or the law enforcement agency or the corrections department. Then there must be causation between that breach and the damages incurred to the inmate. Causation can be either actual, which means direct, or proximate, which means indirect. And finally, the prisoner has to suffer damages. Damages generally, in this context, would be physical damages. But there could be some other types of damages, emotional distress and some others. But generally, a physical damage is what is often required in these cases. Now, inmate suicides are at probably the highest level than any type of population out there. So there is a heightened duty to recognize by corrections staff when someone is mentally challenged or in distress under mental illness, and to make sure that they're safe. And when I say by safe, put in special cells. Monitor 24 hours a day, either by direct video or direct viewing. They are given the necessary medical and psychological help. All sharp objects, obviously, generally are away from their grasp, including the common bed sheets that could be used to hang themselves. When it is evident that a particular detainee has diminished ability to prevent self-injury or cannot exercise the same level of care as an ordinary person because of a mental illness, intoxication, etc., police officers must take reasonable measures to prevent self-inflicted injury. So this heightened level of duty of care kicks in. If an inmate is completely drunk and passed out, you owe a heightened duty of care to their well-being because they can't fend for themselves, at least at that juncture. Now, again, suicides are regretfully, very common in these types of atmospheres because certain people cannot deal with imprisonment, incarceration, jail cells, sharing such a tight space with other individuals, and being told what to do and how to do it. So it's very stressful on a human being. Just think about it. Putting a mouse in a cage or any animal in a very small cage, levels of distress and anxiety increase tremendously. Same thing for human beings. We're not used to that. So foreseeability of suicide is something that all corrections officers and correctional institutions should train their staff on. Some of the common signs, but there's many signs, we couldn't possibly go through them all, is that there's a previous suicide attempt while in custody by the inmate, or the detainee's statements of intent to commit suicide. They actually overtly make these comments. Their history of mental illness. If they have a long history of mental illness, that sends up red flags. Healthcare professionals' determinations of suicidal tendencies. If professionals say, yes, watch out, this one is at risk, this inmate is at risk, then you definitely have to take precautions. The emotional state and behavior of the detainee. Visually, if they are talking to themselves or chanting to themselves, or they are seeing things, that is something that obviously is going to raise a red flag of this heightened duty of care. Circumstances surrounding the detainee's arrest. Certain detainees may not, again, be able to handle jail or confinement, especially if they're arrested under tragic circumstances. Maybe they just killed a loved one, or they accidentally killed quite a few people for some reason. Maybe it's a DUI, and they're under severe distress, or a loved one died in the event that they possibly could have caused indirectly. That is going to be a problem. Maybe the circumstances surrounding the detainee's arrest is very stressful on them. The detainee's level of intoxication or drug dependence, if that's obvious, is a red flag. So, and also if the inmate shows up with removable shoes, belts, and other articles from the detainee, and the other jurisdictional officer has them in a bag, that might be signs that, hey, that other jurisdictional officer believes that they're at risk of suicide. So keep that in mind. These are some red flags that would heighten the duty of care immediately, precautionary care to prevent suicides. Now, shifting gears and talking about the liability of detainees' safety in the general population, certain inmates who commit offensive crimes are at higher risk of assault in jails. And that's an important item to remember. So there's certain like pedophilers or other types of crimes against children. Those particular suspects are inmates may be at higher risk of being assaulted by the other inmate population. So you need to go ahead and take precautions and isolate them on a different section, in a different section of our wing in the correctional institution. certain inmates who display different gender recognition, cross-dressing, or even transgender um, inmates are targets by other inmates. And again, you need to separate them from the general population for their own safety. Sexual preference. Gays, lesbian inmates tend to be victims and victimized by other inmates, are under undue duress by other inmates. And again, the proper procedure is to put them in a different section or holding area so that you eliminate that danger. Obviously, females should not be housed with males um, directly. That would be a problem. And detainees suffering from mental challenges should have a separate ward or are segregated from the general population. These are all general safety tips in the general population. There is a federal law out there that requires the collection of sexual assault data and certification of your facility that it meets certain federal minimal standards to prevent sexual assault. This was actually a federal law that was passed many years ago, and you got to get certified, I think, once every 3 years or so. And it's required by the federal government. And you must have a reporting mechanism for sexual assault victims within your prison. The inmates must be able to report this. And a timely investigation and timely remedying and taking sanction against the other individual who did commit, if that's proven so, the sexual assault. This is all mandated by a federal law here displayed on the screen for you. So it's very important that all jail facilities follow this particular law. If you fall short, you may suffer fines and penalties by the federal government. Your grants, if you're supported by any federal money, and most police departments are, and most correctional divisions are, and correction institutions are, you will lose that funding. So it's very important to conform to this particular law. There is lots of information online on how to get certified and get recertified. There's a whole list of certifiers who are trained by the federal government, and then they go out and look at these prisons. So it's kind of like a third party who's hired by the federal government are actually licensed and trained by the federal government, and then they set up their own businesses and they go around and inspect the jail procedures, the physical jail surroundings, to make sure they conform under the minimum qualifications of this particular law. It's a very interesting cottage industry. I had to enter some contracts with these individuals, and we had to pay them to make sure that we're certified correctly, that our certification it remains in place. So keep in mind of this very important federal regulation. Otherwise, you could suffer severe ramifications if you fall short in performing under this law. Now, violations of national standards can be evidence of failure to meet a duty of care. Remember, duty of care is synonymous, or actually is evaluated under a reasonable standard. And so what courts like to do is they look around as to what is the industry standard in this situation. How many inmates are in per jail? What is the industry standard? Or the bedding used in the jail facility? What is the industry standard? Lots of suicides occurred because of bed sheets. They were used for hanging purposes, and very sharp objects within the jail cells. What is the industry standard on these types of things? Although all of these associations and certifications you see on the screen are not law, these are standards used often, are brought into the courtroom to reflect upon if an agency or corrections department fails to meet the duty of care that is reasonable in the profession or industry. So it is advantageous for jail operators, correctional programs to be certified under one or more of these. I know that the Broward Sheriff's Department is certified under CALIA, and a couple other, I believe, our Department of Detention, which is huge, is also certified under their corresponding parent organization for certification. But getting these certifications not only helps the reputation and morale of workers, because it's rather prestigious, but it also helps in the standing of the community, and it's good proof of no deliberate indifference. And remember, that standard is used in 1983 federal lawsuits, deliberate indifference. We'll come back to that momentarily. But living up to these standards and bringing your certification into court if your organization is ever sued is very, very helpful. So it's good to have these certifications. And by the way, it reduces insurance rates. If your organization is able to get insurance on its operations, it definitely reduces those rates. Now, there are traditional defenses that apply to negligence correction cases. And here are the traditional defenses that we talked about already. So I'll run through them very quickly now. But they're the same as our prior conversations on these. When you sue a correctional institution or a corrections department of a law enforcement agency as an inmate, you have to prove duty breach causation damages by preponderance of the evidence. But there are sufficient defenses, such as sovereign immunity. Remember, these are state level sovereign immunity limitations on various states, and federal agencies have them as well. But the state sovereign immunity really don't apply if it's a federal lawsuit under federal law, because that pierces the state sovereignty limits. In Florida, again, we have a sovereignty limit of 200,000 and on some circumstances 300,000. That's the most that we could lose under a negligence type lawsuit. Under sovereign immunity, it protects the agency itself. Qualified immunity protects the individuals themselves, corrections officers in this case, corrections deputies, jail technicians, if they acted reasonably and in good faith, then they're protected by qualified immunity. There's no Monday morning quarterbacking of their decisions. We've always say hindsight is 20/20. Well, we don't use that 20/20 post incident reflection to decide if the detention tech or the detention deputy or the jailer acted negligently. They're protected under qualified immunity for discretionary actions. Absolute immunity really doesn't apply here, but I could think of only one case if a judge, and remember, absolute immunity is only given to judges and prosecutors generally, if a judge orders an inmate to a certain institution and that institution is bad things are going on to that institution, and even if the judge knew or should have known it was an unhealthy institution, they're still protected by absolute immunity. Contributory negligence. Remember, inmates who are partially to blame, 1% to blame of their own damages, cannot collect anything under negligence due to the defense of contributory negligence. The corrections institution or law enforcement agency would use that as a defense because if the inmate is partially to blame, even 1% to blame, they get nothing. Whereas, and 5 states, I think we've talked about it, about 5 states use contributory negligence. Comparative negligence is different. That's on a sliding scale. You compare the negligence or the degree of fault between the plaintiff and the defendant. If the plaintiff is 30% to blame, if they prevail in their negligence lawsuit, then their damages are reduced by 30%. So that's a little bit different than contributory negligence. Most states are comparative negligence defense cases, or states, I should say. Florida is one. So if the plaintiff is a certain percentage to blame for their damages, their recovery is offset by that percentage or reduced by that percentage. Other defenses are good faith and immediate unforeseen peril. We talked about these. If you're acting in good faith as a jailer, generally that will apply for law enforcement purposes. And immediate unforeseen peril. a life decision. You had to act rapidly in a situation. That's a valid defense. Now, keep in mind, 1983 federal actions can be lodged, and they often are filed by prisoners. Prisoners tend to have a lot of time on their hands, and so they get to know these laws very well, and they can sue. But remember, what they have to do is prove deliberate indifference by the jailers, deliberate indifference by the detention deputy, or the detention tech, or the correctional staff. That's a high standard. Deliberate indifference of a constitutional right or a civil right. Supervisory liability and individual liability is possible if they can prove this deliberate indifference standard. And we talked about 1983 actions and how high this standard is. The Eighth Amendment of our Constitution still applies in correctional institutions. A lot of the amendments, right to privacy, freedom from unreasonable search and seizures, right to carry a gun, the Second Amendment, do not apply in our correctional institutions. However, the Eighth Amendment does, and it prohibits cruel and unusual punishment. It's one of the most common bases for a 1983 action. If you recall, a 1983 action, you have to first prove the actors acting under color of law. In other words, it's a government official doing the job, or on the clock, or even off the clock, but exerting their police power. So the individual is acting under color of law. And secondly, a constitutional right or a federal right is being violated. A civil right is being violated. So the Eighth Amendment is like one of those trampolines in which it's used to launch many 1983 actions against corrections departments. Other jail or prison liability issues: jail overcrowding could be a 1983 action if it rises to the deliberate indifference standard, and could lead to consent judgment decrees to improve jail conditions. There are cases out there where if a prisoner is pro se, in other words, representing themselves in the jail, in their own criminal case or in their own criminal appeals, they are allowed access to legal materials, reasonable access to legal materials to prepare their defense. And so most jails either have a library and allow inmates to check out the law books, or more efficiently, they have Westlaw or Lexis accounts. These are legal research databases, and they have one or two staff members running searches for the inmates. The inmates submit a request, a query, and they're run. I know in our jail system, we actually have 5 dedicated full-time workers actually running searches on Westlaw. That's how large we are. Our inmates will submit requests on forms, and they're constantly coming in. And these 5 individuals staff our law library in the Department of Detention, and they search and print off the results and deliver the results to the inmates. That's considered conforming to this obligation to allow legal materials, access to legal materials by pro se inmates. If there's a disability, you have to reasonably accommodate it, but not to the degree where it would jeopardize safety. Just recently had a query about an inmate who had a prosthetic leg. It was taken away from him because it was metal and it could be used as a weapon. And so to reasonably accommodate him, the alternative that we decided was give him a wheelchair, put him in a wheelchair. That reasonably accommodates him. Even though he demanded his prosthetic, he doesn't get his prosthetic. The law does not require us to make all-out accommodations, just reasonable accommodations, taking in consideration the safety factor. Reasonable accommodation for religious practice of inmates. This is important. This could be a 1983 action if the jailer or the Department of Detention or Corrections Department doesn't allow for religious practices. Unless the religious practice arises an undue burden or a security risk, they generally should allow it. Banning all religious practice surely would be a problem. Courts often look to see, is there a less restrictive measure in place to promote the institution's safety concerns. All institutions, they have rules and regulations because of safety concerns. They have policies and procedures because of safety concerns and orderly processes. However, if the religious accommodation can be made, the practice of the religious belief can be made in a less restrictive atmosphere. In other words, the policies and procedures can be implemented in a less restrictive way to accomplish the same goals, their same goals of safety and security, then in the religious practice should occur. A big case came out of the federal courts 2015. One of the jails, I believe it was in Georgia, but I could be wrong. One of the jails prohibited beards. I think actually it might have been Alabama or Arkansas. But anyway, Arkansas. My mind fails me. It is Arkansas. One of the jails prohibited beards more than 1/2 inches. In other words, you couldn't grow your beard at all. And this was a Muslim inmate petitioned under a federal law, specific federal law, saying he was deprived of a federal right to practice his religion. Under his religion, he had to grow at least a 1/2 inch beard, and the jail would not allow him because of security concerns. They were afraid that the appearance of the inmate could be changed, i.e., jailers may not recognize him with the beard, and then if he shaves it off and tries to escape that night, he may not be recognized because they're used to the beard, or vice versa. Also, safety concerns. The jail was concerned about razors and SIM cards of cell phones in the beard, and it's hard to figure out, is he hiding anything in the beard? Contraband, drugs, needles, things like that. But the court struck it down. The court said, well, you don't make people shave their hair, and all these concerns are still the same for hair on someone's head. So there are less restrictive measures to further your security concerns. You could make the inmate comb the beard and allow it a 1/2 inch beard to grow, and comb the beard in the presence of jailers to see if anything falls out, just like hair combing. They could take a picture of the inmate without a beard and then and let the beard grow up to a 1/2 inch. And therefore they can recognize the inmate with a beard and without a beard. So there were other alternatives. And so remember, reasonable accommodation of religious practices is required. Not all out accommodations, but reasonable accommodations. If it jeopardizes security, then you could crack down and reject the religious practice. Searches of inmates in jail units. Generally, there is no right to privacy in the jail. The inmates have lost that. Temporarily or permanently, depending on how long they stay there. As long as they're within the institutional walls, they lose that privacy right. They can't sue for violation of privacy because they're being watched and video recorded, and they get no me time, solitude time. Oh well, that's the nature of being in jail. A Fourth Amendment, reasonableness searches. Again, you don't need a warrant in the jail to search a jail cell. The Fourth Amendment generally does not apply. I mean, you could be overcautious, and if you suspect that, and we're talking about inmates' property, not workers' property, because that would be different. But inmates' property, the reasonableness does not apply. I mean, you can search jail cells unannounced. You can have body searches. These things are all allowed. Same-sex strip searches, though, should be conducted by same-sex individuals. So, in other words, males conducting male strip searches and females conducting female strip searches. Prisoner transport services. One thing I learned that I didn't know before is that this is a very small pond of vendors that do this. It's very expensive to move prisoners out of state, from state to state, and maybe even country to country. Generally, the federal marshals will not do it if it involves just state claims. And so you have to either use your own staff, which is tremendously expensive, or you can hire a prison transport service. And these are private companies around the United States. There's not a lot of them, and so there's very little to choose from. They tend to be expensive, but they're cheaper than probably doing it yourself. There are some liabilities in this area. When you enter a contract, and yes, you should have a contract in place between your organization and the Prisoner Transport Service Organization. Make sure they're certified in law enforcement techniques or handling of equipment. Make sure they indemnify your agency. In other words, there's a clause in the contract that says if they do any harm to the inmate or cause your organization, your law enforcement agency damages, i.e., your organization is sued because of their activities, their mistreatment of inmates while the inmates were in their custody, care, and control, they indemnify the agency. They make whole. They indemnify and make whole the agency. Reimburse the agency. That's a fancy word for reimbursement. Make sure these prisoner transport services are inspected periodically by your own staff. Unannounced inspections of their vehicles, of any of their holding cells, of their licenses. Make sure that they remain incorporated and don't get administratively dissolved by the Secretary of their state. Make sure they're in good standing. Make sure all complaints against them are investigated. If inmates say, I didn't get a meal the whole day when they were traveling and shipping me from the Florida to Massachusetts, they never offered me a meal, that could be a problem. So you should investigate all complaints and timely address them and remedy them if they are true. Make sure these prisoner transport service vendors are insured. That's a big one. Make sure they have big policies because they are shipping human cargo. The human cargo is your responsibility and you're contracting with them to ship it. So just like anything else, you'd have insurance. Here you'd have lots of insurance because lots of things could go wrong. The inmate may escape. The inmate may do harm to themselves. The prison transport company may do harm to the inmate. So there's all kinds of things. There might be medical conditions that arise along the way. So make sure background checks are done on and conducted on these business owners so that you're not doing business with someone who's a felon and you're turning over your prisoners to someone who's a felon. Alternative community control release programs, very valuable out there, very popular. It's very expensive to keep somebody in a jail, at least $36,000 a year on up. That's just for one prisoner, for the food and the care and the health care, etc. So alternative community control release programs are very popular out there. But as you might expect, like anything else in law enforcement, there are liabilities that attach. Make sure that only nonviolent offenders qualify for these community control release programs. Mobile monitoring devices should be used, ankle bracelets. Make sure the system of reporting and tracking and spot checking is in place for any of these control release programs so that there are spot checks, maybe even in the middle of the night or during the day. They are where they're supposed to be. Drug reporting and testing policies in place and enforced. Make sure that all drug tests are done random as well as once a month or whatever the period of time that the judge puts in the order. Work release programs, these are also very popular. I know that our prisoners at our jail, if they qualify, they can work during the day. And literally, they're escorted by a deputy and they work on county property. They pick up trash on the roadway. They paint county-owned buildings. They do maintenance work on county-owned buildings. They're nonviolent individuals. They are escorted and they wear their prisoner jumpsuits so it's obvious. And they're let out for the day. Actually, it's good morale for them. They're able to build up a little bit of a commissary account. They're paid a little bit, but not much. They're allowed outside of their jail cells, and sometimes they learn different skills. And so they are appreciative of these programs as well. And that's okay so long as they're conducted and there's safety mechanisms in place, security in place. Otherwise, there could be huge liabilities for allowing these inmates to commingle with the general public itself. Inmate healthcare and infirmary liabilities. Basic medical care must be provided and afforded to inmates and available to inmates. I know at our organization, we actually contract out. It's a very large, expensive contract, but we turn over medical care to a company which provides the nurses and doctors. And we have an in-house basic infirmary. And if anything else, if it's too severe, if the conditions are too advanced, or if the medical treatment is too advanced, then they're brought to the hospital. So my recommendation to control the risk here is to contract this duty out to properly licensed and insured medical providers, and let them operate out of your facility. Give them a room, a medical room, and they can provide these services. Otherwise, you have to hire generally professionals, a nurse practitioner, a nurse's aide, and maybe even a doctor. And that can be very, very expensive. So you can buy or you can enter contracts for this healthcare, and that's what I recommend, because then you remove the liability from your agency, because there's a lot of liability here. Misdiagnosis or prescriptions of certain drugs, maybe an overprescription is actually accidentally done. That's all of this company's problem, not your agency's problem. Obviously, if there's more extensive care is needed than your average Band-Aid or a short little visit to the jail hospital, then transportation of these inmates to a local hospital is required. There is a duty of care there, and you do have to transport them and make sure that they're monitored and there's someone with them 24 hours a day, a deputy, armed deputy. Because you don't want to just transfer them to the hospital and leave. I think that's pretty obvious, but we want to make sure we cover it here. You always have to act timely in all medical situations. And this is a big issue here, if your agencies like the Broward Sheriff's Department, we accept prisoners. And in fact, we have to house prisoners that are taken into custody throughout our county. So all the small municipalities, the police departments, they deliver their prisoners to our jail, and we have many jail facilities. But we have a standard operating procedure that if the prisoner shows up and he has medical conditions, he's bleeding, he's complaining of a broken leg, then we don't accept custody of the prisoner. We tell that jurisdiction's officer to go and bring them to the hospital and get a clean bill of health before you bring them to our prison. That way, the liability is on that jurisdiction, that city's officer, not us. So we only accept prisoners that have clean bills of health, no obvious signs of immediate medical treatment needed. And once a prisoner is brought into our facilities, and I recommend that this is a good way to reduce liability as well for your facilities, your jail corrections facilities, is to document. Make sure you take pictures and journals and entries to make sure you note any physical situations, any physical abnormalities, any bruising, any blood, any missing teeth, those kinds of things. And so you document the medical condition of the inmate with pictures and journal entries to memorialize how they entered your institution. It's amazing how many claims occur against jail institutions and jailers of conditions that occurred outside the jail. The prisoner's taken advantage of them now. So keep that all documented. The key here is to document. Make sure that the inmate arrives and is checked in and is thoroughly evaluated before put into the jail population. Inmate visitation, phone calls, and commissaries. Yes, believe it or not, there's legal issues there as well. Phone calls can be regulated, can be monitored and recorded, so long as there's a clear message to the caller-ins. The people calling in are in the phone bank area, that the messages can and will be recorded. That dispels any expectation of privacy. Some courts have said you don't even have to do that for jail facilities, but we do that. We put everybody on notice, and that way they know that they're being recorded. Rates for phone calls. In 2015, the federal government had implemented a new regulation that caps rates on phone services. And this is big business. Millions of dollars are involved in these types of contracts. Usually jail institutions like ours, our sheriff's department, we contract with a phone provider, and that phone provider charges fees on phone calls from the jail. And that's a very lucrative business. But the federal government now is cracking down on just how much fees can be charged, because these fees tend to be excessive. They had a disproportionate impact on minorities. And finally, studies show that the more phone calls and interactions with the outside world these inmates have, the less chance of recidivism down the road, because they're staying in contact with their family members. They're staying in contact with their friends, with their religious leaders. And this is a good thing. We want to encourage that. But high rates on phone calls discourage it. So the federal government, after doing much studying, has now capped out these fees and rates. And many of these contracts, which have been in place for years and years, have to be renegotiated. And the pricing has to be reduced tremendously. Video visitation is the trending thing right now. Instead of physically going to visit the inmate, video visitation is generally acceptable, legal, and it's not a violation of someone's right to actually physically see somebody. Other than attorneys seeing their own clients, you can institute a video visitation policy. But just remember, the rates on those video visitation systems have to conform to the federal caps recently announced because of the same public purposes involved. Refund of commissary deposits. Often inmates are given commissary accounts. I know our sheriff's department allows inmates to have commissary accounts to buy little things, sandals or cookies or things like that, reading materials. And so refund of these commissary accounts are required once the inmate is released. And the way we do it, we're a very large organization. We just issue debit cards with the amount on them. And again, these accounts are not huge. Collectively, they're huge. The amount of money that we have to manage, it's almost like a banking system. But generally, the inmates are capped out at like $30 or $40 in each of their accounts. Generally, it's very rare that any of them would have more than $100 on their individual accounts. Most of these cards are issued at $15 or $22 or something like that. But they are inmate money, inmate property, not the state's, and so you do have to return them after they're released. And the best way to do it is just hand them a card right when they leave, and they sign for it, and it's taken care of. So these refund of commissary deposits are required. The final issue that we do have to have a conversation on is a very controversial issue: privatization of prisons. There is a very strong push for privatization of prisons throughout the United States, mainly in the South, it seems. In Florida, there's a very strong push for this. And there are a couple large companies that are willing to take over the prison systems themselves and run them as private operations. And there's a lot of economic upside to that, to states and counties, because the cost of the prisons are millions and millions of dollars reduced. These private companies can run them more efficiently. How can they run them more efficiently? Well, mainly, they don't have to deal with government unions, union members. Union members in government are very strong. I know in our department, we actually have two different corrections labor unions, and they have bargain their rates to a certain level and benefits that are mandated. Whereas private prisons, they don't have to deal with unions generally. Now, if a union is ever formed, they do. But generally, they start from a clean slate. They can pay, I hate to say it, minimum wage to their jailers. Highly unlikely they would, but they could. So these prisons are able to run via the privatization process. I personally don't like this idea. I think that police power and corrections power should be held by the government, should be law enforcement agencies and valid government corrections departments and agencies, because those agencies report to the people. If you privatize a prison, you lose a lot of the checks and balances of reporting to civilian authority. And it becomes a monetary operation. And to reduce costs like any business, these private prisons are surely going to look around and see what they can get away with, what they can cut from the expenses. Maybe prisoners don't get 3 meals a day now. They only get 1 meal a day. Maybe they don't get, 2 hours out in the rec yard. They only get 20 minutes. Things like that. And we really have a problem here because the driving force between privatization of prisons is the more inmates, the merrier. They generally get paid per inmate. And if the jails are not full, then these prison companies don't make as much money. So they have an incentive to keep the jails full. They have no incentive to provide training, education, and other types of programs to reduce recidivism. They would like recidivism. They would like high rates of recidivism. They like repeat customers because it keeps their jail cells full. And that's a problem. So this is a very controversial area. It seems to be trending right now. There's a big movement towards privatizations of prisons. There's pros and cons to it. But we'll let that discussion play out beyond our class here, but I wanted to bring that to your attention. Obviously, the liabilities from a government perspective generally is when you turn over the prison completely, there's very little liability. I guess that's what makes it attractive. This company now has to perform. I would make sure the company is very well insured and make sure they're very well capitalized so that if there's a death of an inmate and a big lawsuit occurs, these companies can weather that potential judgment against them. It's very controversial, again, handing over such power to these prisons. Privatization of prisons is definitely a big topic out there.